All right, for more on this, let's now welcome Advocate Brenda Madumise-Pajibo, Director at Wise Collective. Advocate, thank you so much for your time. Welcome. So let's start with this perfect example of this case, right? Never seen before, where convicted individual actually seeks to lay bare on the miscarriage of justice by our courts. Talk us through this matter as well as its objectives. Advocate, please unmute.
Sorry, my apologies, I was muted, sorry. So what she's trying to do really with the help of Center for Applied Legal Studies, and we as WISE are going to be amicus curiae in the matter once it goes to the Constitutional Court, is to bring into sharp focus the battered syndrome approach, right? That we discount in this country. We don't believe that there is a battered syndrome and that women suffer from battered syndrome, that if you have been battered for extensive lengths of time, you become immune to your violence and you think that it's acceptable, and then you react out of that persistent violence, and you do something about it. So the courts have always been not willing to open up that conversation and debate and allow experts to come and testify about what battered syndrome means and what it does to individuals. And that's the point that is being taken, that will be dealt with in the Constitutional Court.
And that's exactly it, right, Advocate? I mean, having been exposed to court processes, and I'm talking about South African court processes and how the legal system actually relies on the paper book set of processing in specific matters. In this case, I mean, the aggrieved raises the issue that her history, as you've just mentioned, at the hands of the deceased, who was her abuser, should have been considered above all circumstances. I mean, we know, as you've just mentioned also, other countries like your US actually make specific provision for that battered woman syndrome context. So why are we not on par with such international law standards, you think?
Yeah, we are not par precisely because I think we've got conservative judiciary. We also have laziness that creeps in, not wanting to push the envelope to challenge some of the laws that we have before us and try and bring new concepts into our jurisprudence, and and it's necessary that we do so, and it can only be through the work of CAS and others to bring into the open some of the concepts that we can use to challenge the norm that has been for the longest of time. So I think it's going to be an interesting case to watch. It's going to force many people to grapple with what battered syndrome is, and really talk about the trauma visited on a victim. I think we don't spend enough time on talking about what is that trauma. We literally pass it and we are flippant about it, right? And so we have not, as a country, really applied our mind and interrogate the trauma that is visited on victims of violence.
Absolutely. And Advocate, I mean, that trauma can also outline, sort of give you a background of why this person actually acted in such a manner that they acted. We're not saying we're excusing, of course, cases of gender-based violence, but I mean, it's special circumstances that, of course, somebody will actually lose it to a point of murdering someone. But look, with the new GBV laws, Advocate, also being implemented and ever evolving and being put into our constitution, when will we see such drive towards a better management of such cases? What does the state or our constitution actually need to have or need to be reformed in terms of ensuring that those that are actually seeking clarity in terms of their sentences or are looking for the court to consider exceptional circumstances when meting out their sentence?
You know, the travesty in all of this is that unless you have organizations that are willing to challenge some of these things. And remember, it takes resources to do so, right? So these things are not for free, right? And you've got many victims of violence who are sitting with very good cases that can serve as test cases, but they don't have the resources, right? So they just leave them, and there's no reform that will take place. So part of one aspect about this case is that it was taken up because I think once Carls read the papers, they realized that there was miscarriage of justice, that you ignored so much evidence in this case, that you really wanted to apply a single straight line when it's not a single straight line, right? And we are now saying to the court, can you look at the detours and everything else in this case so that you arrive at, and we can bet you that we are going to arrive at a different decision and conclusion. So it's the reform of the law and the form of amendment of our constitution will only happen once we put cases before courts to test whether this constitution is robust enough to withstand some of the nuances and the aspects that we want to bring in, lived experiences of a victim that must be highlighted and must be addressed and must be taken into account.
And I suppose, Advocate, that would mean also, I suppose in those in your position, as well as the court marshals, the advocates, the magistrates, the judges as well, will have to then also undergo a lot of reading around these reforms, because I suppose the interpretation around these amendments is quite a lot to understand.
Not true. No. I think it's very true that once there is a change in the law, and you'll see that there's a change in the law in how we look at rape in this country now. It was a decision last year. You will see the court judgment on consent. It was a watershed case on consent. So it requires prosecutors, it requires clerks of courts, it requires magistrates, it requires judges, everyone to be on top of the changes in the law and understand the interpretation and application of that law. The Justice Department has got an obligation to ensure that those who are employed by justice, especially magistrates and judges, undergo that sensitization program and they're kept abreast of what's going on. But remember, as judges, and in the legal field, you are driven largely by precedent, right? And we expect you to have read, to know what is the current laws and what are the cases that support your argument. And so you can't come before a court and argue something that was done away 5 years ago. You need to be current. Law is about reading. It's about every day, familiarizing with yourself with the changes in the law, familiarizing with the change with case law, and that's literally what we do on a daily basis, is interpret that and use the cases to advance your argument.
Absolutely, Advocate. I mean, somebody was even saying with so much recon that also needs to be done by the judicial senior staff, maybe we need to start looking at the syllabus, because the new incoming future lawyers, future judges, future magistrates will also need to then also be in line with all these new pieces of legislation as well as policies that is currently being effected. Advocate, we really appreciate your time. A great conversation with you. Yes, great conversation with you. That is Advocate Brenda Madumise-Pajibo. She's the director at Wise Collective. She was talking to us about that case where a woman, a lady, is actually seeking an appeal in her sentence after she was sentenced. And she is arguing that, of course, the court did not take into account the fact that she was a battered woman and that possibly her abuser had led her to commit that crime.